This is an adversarial system. One of the interesting things for people who follow, patent law, listening to the two previous presentations, is how much of this is ending up in the Canadian courts rather than in the Canadian Patent Office that's making the determination of the original patent. This is because of the change in 1995 that drove adjudication of patents into the courts and made that the primary venue for international manufacturers to fight with Canadian-based generic manufacturers. Now, in 2002, the Canadian Supreme Court threw another challenge forward. In a decision on a patent case, the Canadian Supreme Court said that in the matter of utility, the standard of usefulness requires two things: demonstration of utility or sound prediction of future utility in the case of a drug which hasn't been through clinical trials prior to the patent application, because the drug manufacturer wants to hang on to the intellectual property before it gets loose during clinical trials. That created an opening under which courts could then interpret or question the utility component of the patent application post facto as well as pre-decision. And this is something that both of my colleagues have brought up, but I wanted to put it in that specific Canadian context, that this began with a Canadian Supreme Court decision that redefined the way Canada would deal with this particular component, which is why utility, largely not contested internationally, has become so important in this particular case. Now, in 2006, Canada made an additional change to the compliance rules to limit the options for generic manufacturers to challenge international manufacturers on patents. This was under severe American pressure because we had a number of issues with the way Canadians handle intellectual property. Some of you will know USTR, beginning in 2000, began listing Canada as an intellectual property pirate, putting them on the same list as China and other countries. There was a lot of pressure in our trade negotiations with Canadians over a number of issues on this particular issue of pharmaceutical patent rights. And so in 2006, the federal government attempted to tighten that up by issuing some clear directives on the notice of compliance process and when ministers of health should not issue a notice of compliance. They made it clear that patent rights were more exclusive than they'd been previously interpreted in the hope of ending some of this tension. But that set the stage for courts, and this is the story that brings us here, for courts in Canada to develop something called the promise doctrine, looking at the implicit promise of the patent application to make a post facto judgment on infringement based on a change in usefulness, either because the sound prediction was a false prediction or because the demonstration was insufficient, which is the basis for these cases. This, however, opened us up to an ongoing dispute over Eli Lilly's particular drugs, which I think Dr. Kilic explained very well. Now, NAFTA Chapter 11 does provide investor-state disputes resolution here, but from Eli Lilly's point of view, it's a limited good. On the one hand, they can sue the government of Canada and ask the government of Canada to give them compensation for the lost patent right in monetary damages. That doesn't extend their patent right. It doesn't prevent their drugs from being copied. It sets a precedent. They lose market share as well in Canada. So it's compensation at its best, but it's not a resolution of the problem that brought them to court. It's less good than a change in Canadian law or legal interpretation that gives them back their patent right. It's also tricky for the international community because as we approach intellectual property negotiations with our Asian partners in the Trans-Pacific Partnership, we've also brought IP very much to the center of the Doha round negotiations and whatever succeeds them post-Bali. We've brought intellectual property rights into the dialogue in the Transatlantic Trade and Investment Partnership with the Europeans, and we have been arguing with both Mexico and Canada in bilateral forums on these same issues. The extent to which a NAFTA Chapter 11 panel simply disciplines the government of Canada rather than changing Canadian law opens us up down the road to challenges to using investor-state dispute resolution and will put tremendous pressure on us to ensure that these other agreements have tighter intellectual property rules. But it also creates an opportunity to use the pressure of ongoing negotiations to get Canada to change its law again. This has been the route that we've taken now for decades. when Canada has found itself out of line with the way the US would prefer and other international partners would prefer that it handle pharmaceutical patents, we encourage, a large trade negotiation, Canada to bring its law into conformity. And this is the ironic thing. Prior to the NAFTA Chapter 11 dispute being filed, Eli Lilly's great hope was that the Supreme Court of Canada would look at their appeal and consider issuing rulings that would tighten up the use of the promise doctrine in a way that would be beneficial to Eli Lilly. And the Supreme Court of Canada denied the application for appeal, denied hearing the case, leaving Eli Lilly frustrated. It went to the government of Canada and said, we'd like the government of Canada to intervene, either by changing the regulation to define the utility in a tighter way, or once again, bring in new legislation to tighten up the system. The government of Canada did not choose to act in that regard, and so Eli Lilly, I think, took the NAFTA Chapter 11 route in some frustration. But we still have an option for the government of Canada to act here. And doing so is in the Canadian interest because it avoids putting this issue into international arbitration or into some sort of future trade negotiation setting where Canada might be disadvantaged. The first thing the government of Canada can do is send a reference. In the Canadian system, the Parliament, the government of Canada can send a question to the Supreme Court and ask for a ruling on that specific question. You don't have a question of standing. The question would be, do we need to legislate or redefine this term, utility, in light of Canadian patent law? Do we need to go back and pass new legislation, or should we handle it through the regulatory process? The Supreme Court can respond to that within the Canadian system and provide some clear definition or no answer. The government of Canada, with a majority in Parliament, can pass new legislation, which would be a second step that would work to resolve this dispute. And third, the government of Canada can try to set up some sort of mediation between the generic manufacturers and Eli Lilly itself. But the problem we now have with Chapter 11 is that while a Chapter 11 dispute panel is being heard, the government of Canada, the civil service of Canada, is unlikely to do anything on this issue, waiting for a NAFTA Chapter 11 panel to resolve it. We've put ourselves now in limbo because of NAFTA Chapter 11. So I would hope we could suspend the Chapter 11 case, we could move back to a Canadian solution to this Canadian problem to resolve this in a timely fashion prior to the ramping up of negotiations in Asia and across the Atlantic. That would be the path of peace, the very sensible Canadian solution I would recommend.